American class action. It's an opt-out class action rather than an opt-in class action. You hear people talking about joining a class action. You don't join a class action. You are in it unless you affirmatively do something to get out of it. And so that creates potential conflicts of interest because the attorney, when settling a class action, and if a class action isn't discarded by a court, they usually settle. Very few of them go to trial. As they're negotiating the settlement of the class action, they're both negotiating the compensation for their clients, the class, but they're also negotiating their own attorney fee, what they will get paid for bringing the class action for whatever success they have achieved in the class action. Now, who's looking out for the absent class members? Well, the defendant doesn't care. They just want to get out of the case as cheaply as possible. And the individual class members, just as it's inefficient for them to bring their own case individually, it's also inefficient for them to monitor the class action settlement and see what's going on. However, the judge, the court, is supposed to be looking after the class members. They have notice, they have a hearing, because as due process requires, you're extinguishing the rights of absent class members in the settlement. They'll be releasing claims against the defendant. So that cannot happen unless the judge approves the settlement as fair, reasonable, and adequate. So to the extent that you have this conflict of interest, the parties can't do anything too blatant. They can't go and say, okay, judge, we've created this $8 million settlement, so we're going to pay $7 million to the attorneys and $1 million to the class. The judge might look at that askance. If the class is compromising their claims, why is the class compromising the claims but the attorneys aren't compromising their claims? So the way the parties get around that is to sort of create the illusion of relief, to sort of hide what's actually going on economically, and hope that the judge doesn't notice. And because judges are used to the adversary proceeding, they're not really equipped to do investigations. They're not equipped or have the experience to understand when parties are sort of hiding the ball and creating the illusion of relief without actual relief. And so far, there's no ethical requirement of candor to the court about these things or consequences for failing to have complete candor about what's actually happening. You have some crazy situations come up where there is the illusion of relief. So that $7 million versus $1 million isn't entirely hypothetical. That's the actual ratio in the case of Rosenio versus Henderson, a class action settlement over Conagra's Wesson oil product and their labeling. That Henderson, by the way, is our very own Todd Henderson. Some applause, please. But in that case, 998 F3rd 1014, the parties did settle with the attorneys getting $7 million and the class getting $1 million. But they go to the judge and they say, look, anybody could have made a claim for 45 cents. And if everybody had made a claim, there would have been 20, 30 million paid out. How are we to know that it was only going to be $1 million? And the answer is, well, you know that there was only going to be $1 million. That you didn't give direct notice to class members. You didn't directly pay the class members. You were counting on them to file claims. And when that happens, you know that there's going to be a low claims rate. And in fact, it doesn't matter whether you know, because Rule 23E2C2, when evaluating class action settlements, you look at the effectiveness of the distribution, and at least we argue that that's an objective standard. You don't look at whether the parties subjectively thought that they were going to give away a lot of money. But with that illusion of relief, with the illusion of an injunction that bound Conagra not to do anything to the Wesson oil label, which they no longer owned, the district court approved the settlement, and we had to go to the Ninth Circuit to get that reversed. And on remand, the parties, after again trying to get that settlement through, but the judge seemed through at this time, negotiated a new settlement where the class was getting twice as much money. And the attorneys weren't getting $7 million anymore. Cypre is a doctrine from the concept of trusts. The idea being you have a charity, you're the March of Dimes, you're established to cure polio, polio is cured, nobody wants to lose their phony baloney job working for the charity, so they redesignate the purpose of the charity, si près comme possible, the French, as near as possible. You've noticed in law that if you want to make it sound fancy, you use French or Latin. So Cypre, under the Cypre doctrine, the March of Dimes redesignated itself, and now it's it goes after birth defects rather than polio. Some law students at the University of Chicago came up with a comment saying, hey, why not apply this to class actions? Instead of giving class members money, you could give it to some charity, and the charity would do good things for the class members, and that would be more efficient than actually paying the class members. And some lawyers got a hold of that and thought, hey, what a great idea. And that leads to all sorts of potential abuses. Well, what are those abuses? Well, the class counsel is supposed to have a fiduciary obligation to the class. They're supposed to be looking after the class's interests, and the class probably wants to get paid. Normally, when you have a client, you can't say, well, client, you have a lot of money that I have control over, and you would just spend it or do something socially unproductive with it. I don't like you, client. I'd rather you spend the money on charity, and I'm going to take your money and give it to charity. That's generally called embezzlement, no matter how noble your goal is with that money. If my client is some horrible billionaire who's just going to spend it on a social media site, I can't just take his money and give it to charity. But we seem to allow this in the class action process, and my organization, which is a nonprofit that objects to bad class action settlements, has been fighting against the idea of Cypre in class action settlements. Well, what are those problems? And like we say, it creates the illusion of relief. So many settlements, often with large tech companies, are established as Cypre. They say it's too hard to get the class money. The defendant is going to give money to charity instead. And sure enough, it's charities that the defendant was already giving money to. It's just a change in accounting entries. Or the nonprofits are nonprofits that are ideologically aligned with the defendant. So Google will divert money to organizations that support Google's views on copyright, even if they hypothetically disagree on privacy. So it's creating the illusion of relief. The settlement is only costing Google $2 million, but the parties say, oh, it's an $8 million settlement, and $2 million is going to the attorneys, and $6 million is going to these nonprofits that Google has selected. Another way that it creates the conflict of interest is if the nonprofits are affiliated with the attorneys. So in Frank v. Gauss, the underlying settlement with Google, the money was not only going to a bunch of nonprofits that Google had the pre-existing relationship with, it was going to the alma maters of the lead class counsel. So they would get to have a nice ceremony at their law school, hold a big oversized check, look at how much money I'm giving the law school. No, it's your client's giving the money. But then they're getting a commission on top of that for the money that they have won for their alma mater. So in effect, the attorneys are sort of double dipping. Other potential conflicts, the judge might say, oh, I'll approve the settlement if you direct money to my favorite nonprofit, and that's happened a few times. Or the judge is asked to pick the nonprofit. The judge is sort of given a slush fund to decide where the money goes. So you had a class action in Puerto Rico over a hotel fire. the judge decided that he wanted the money to go to the local cats and dogs charity. But again, if the judge knows that there's that slush fund coming, the judge might be incentivized to sort of give rulings that lead to a settlement lead to a larger settlement with more Cypre. Another potential conflict of interest is that the attorneys might prefer that money go to the nonprofit instead of their own clients. If the attorneys are going to get paid the same whether their clients get the money or their favorite nonprofits get the money, well, you know, if I win $5 from my client, they're probably not even going to send me a Christmas card, whereas I can have a big ceremony celebrating me if I give the money to a large nonprofit that is ideologically affiliated with me. But there's also the problem that the attorneys aren't incentivized to actually try to get money to the class. So there was a big 9-digit settlement with Volkswagen over the Volkswagen diesel scandal. And class members, every single one of them was identifiable because, you know, you have a Volkswagen, Volkswagen knows who you are so that they can notify you about recalls and that sort of thing. It would have been really easy for these class members to just get mailed checks for $1,000 to $5,000 each, as they were supposed to get. Instead, they created a claims process, and while the claims process was relatively good in that over 20% of the class got money, that left 77% of the money unclaimed, and it all got diverted to Cypre instead of the attorneys having an obligation to try to get that money to their clients. So, well, what have courts done about that? And some courts have been very good about this. The Fifth Circuit and the Seventh Circuit, and to a lesser extent the Third Circuit, have said, no, you need to prioritize class recovery, and either you can't have Cypre at all, or it has to be absolutely a last resort. And then there are other courts like the Ninth Circuit, the circuit where the Volkswagen case was and where all these Google cases were, that hold Cypre is just another kind of relief, and it's just as good as actual money to the class, notwithstanding Rule 23E2C2. But we have found that when you actually ask attorneys or tell attorneys you need to get money to the class members and you don't get paid unless the class members get paid, suddenly they stop claiming it's impossible to get money to the class, and they actually find a mailing list to do direct distributions or create a claims process where the class members get paid. So we took that one of those Google settlements to the Supreme Court. That turned into Frank v. Gauss, which I argued in 2018. The Supreme Court, unfortunately, other than a Justice Thomas dissent, did not address the underlying Cypre issues, and remanded on the grounds that the Ninth Circuit had not followed appropriate jurisdictional questioning under Spokio and Article 3 case and controversy requirements, or standing requirements. It got remanded. The district court found, yes, there is standing to bring this lawsuit under Spokio, and then the parties settled, but so that we wouldn't object again, now they got actual money to the class instead of the class getting $0. There's a $23 million fund created, of which the class would get about $16 million. So 2.5 million class members are getting paid about $7.5, as opposed to $0. So small victory there. Would have been nice to get the precedent saying don't do this in other cases, and then it wouldn't have happened in the Volkswagen case where there wasn't any notice or any publicity or even a judicial decision. It was just $70 million diverted to nonprofits and to Cypre, and it probably doesn't even get registered in because there wasn't a published opinion. It's not even going to be in any database. It was only because we noticed that anybody knows that this happened. So the Ninth Circuit's bad about it. The Eighth Circuit has a mixed record on this, with 2 identical cases coming to 2 exactly opposite conclusions. In Bank of America, a 2015 decision, there was a $400 million fund with $3 million left over. The judge says, let's just give it to the Legal Aid Society in Missouri. Class members objected and said there should be another distribution to the class. The Eighth Circuit agreed in a 2-to-1 decision. But we went back to the Eighth Circuit with another settlement, this one involving Monsanto. There was a $35 million fund, and the ratio was even worse than in Bank of America because the class was only going to get $10 million. The attorneys were getting $14 million, and there was going to be $16 million going to nonprofits. And to add insult to injury, the nonprofits were going to be these left-wing organizations, such as the Berkeley Law School Environmental Justice Center. And if you know anything about the suburban homeowners are getting $14 million, and their favorite law school is Berkeley Law School. So we objected both to the fact that the district court wasn't following Bank of America and making sure that the money actually went to the class members, but also on First Amendment grounds that, and 23A4 grounds, that this was an inappropriate recipient, that was sort of compelled speech for the absent class members in terms of sort of compelling them to take a left-wing position, and at least half of the class surely would object to that if they had the opportunity to. And under Supreme Court jurisprudence, silence is not consent. You have to actually ask people to opt in rather than requiring them to opt out from that. The Eighth Circuit held that there wasn't a First Amendment problem because the absent class members had no right to their own money. That was won on their behalf in the class action settlement, creating a circuit split with the Fifth Circuit that holds that it is their property, and also sort of a circuit split with the Eighth Circuit, where in Bank of America they said it was the class's money. And they said, well, the parties tried really hard to get the class money, or at least they said they tried really hard to, and the judge agreed with them, and we're going to defer to the judge's finding that they tried really hard. And since they tried really hard, they get to divert the class's money to the nonprofits rather than to the class. Of course, Bank of America, the district court made the same findings, and the Eighth Circuit threw that out. We tried taking that en banc in the Eighth Circuit. The Eighth Circuit denied en banc review by a 6-5 vote. So if you're clerking for the Eighth Circuit in the future, try to push your judge to sign off on those en banc decisions in the future. But we took it to the Supreme Court, St. John versus Jones. We were enthusiastic about it. We got several state AGs filing amicus on our support, several other amici. SCOTUS blog named it a petition of the month. There was a lot of publicity over it. And the Supreme Court, at their first conference, held it over for a second conference, and then for a third conference, and then for a fourth conference, and then they denied cert. So my bad cert petition, I guess. But we're hoping that the Supreme Court does take this up again. Justice Roberts has written about the potential problems of Cypre. Justice Thomas and Franklin Gauss has written about the potential problems of Cypre. And we do have a circuit split out there where some circuits will let you divert class members' money to third-party nonprofits, and other circuits will not. What's another problem with Cypre in addition to all the conflicts of interest I discussed? Well, say you have a $200 million class action, but you only have a 1% chance of succeeding. But you can structure the illusion of relief so that you get paid the entire $2 million settlement value. You create an imaginary $6 million Cypre fund where the defendant changes some accounting entries, and money that was going to send to charity anyway is now called Cypre. Now it's profitable for the attorneys to bring this low value, low success, close to frivolous lawsuit. If, on the other hand, they had to share that $2 million with their clients, so that it was $1.5 million to the class and $500,000 to the attorneys, now it's not profitable to bring that low value case, that low merit case. And we're sort of, with the availability of Cypre, with the availability of illusory relief, we are sort of creating the incentive for class action attorneys to bring low merit cases, low value cases that can only settle for nuisance amounts, that they would not find profitable to bring if they had to share the benefits of that settlement with their clients. Look forward to hearing from Professor Hubbard and look forward to answering your questions. There are always good ones here. So thank you.
Okay, thank you, Ted, very much for those remarks, and thank you to the Federalist Society for inviting me to participate in this conversation today. As those of you who have taken advanced civil procedure know, I'm a big fan of Ted Frank's work, and that makes my job as a discussant somewhat difficult. Because, you know, this is the University of Chicago. I'm not here to get up and agree with the speaker. I'm supposed to provide, I think, some at least distinct or maybe contrasting perspectives. And that's hard to do since I basically agree with everything he said. But I will try to offer something. I will try to offer something because I do think that there are some loose ends here. I do think there are some loose ends here, and I do think it's worth attempting to try to figure out why is it if it just, given the nature of the problem and the kinds of patterns that we see in terms of funds that could and taking the law as written should be going to class members, and those funds are not going to class members. So, so first of all, I think in the interest of full transparency, and speaking of conflicts of interest, I should acknowledge a conflict of interest of my own. If any of you are in the position to settle a large class action with a Cypre award, please direct it to the University of Chicago Law School. So take everything I say with a grain of salt, given where I'm coming from. One very, very minor clarification that I want to make of one word, literally one word, that Ted used, but I think is something that I really like to get on my soapbox about when we talk about class actions, and that's the word joinder. I think it is very commonplace and a sort of a convenient shorthand to talk about class actions as a device for joining parties to a case. But as we will talk about in civil procedure a little bit later this quarter, for those of you who are 1Ls in my class, the class action device under Rule 23 is not joinder. It's actually anti-joinder. And what I mean by that, I think, illuminates a lot of the, sheds light on at least, a lot of the problems that that we just heard from Ted. What do I mean by anti-joinder? When there is a large group of people who have allegedly been injured by a single act or course of action by a defendant or defendants, and especially when each individual person's injury is relatively small relative to the cost of litigation, there's no economic incentive for any one individual to actually bring that suit. And yet, if just by stipulation, if those injuries in fact occurred and are in fact the responsibility of the defendant, then the law should provide relief for those injuries to the injured people, and should provide a procedural vehicle for that relief being delivered, and that's what the class action is. But importantly, the class action device, what it does not do is fix the economic incentives that make it nonsensical for any class member to try to do anything about their injury. Whether you're in a class action or not, it's more expensive for you to participate as an individual than the amount of relief you can expect to get. The class action doesn't fix that problem. Rather, it attempts to address that problem through a different means. The different means is, rather than giving the class members the means to assert their own claims, it provides a mechanism by which their interests are represented by somebody else and attempts to protect and ensure and incentivize the alignment of interest between the absent class members, as one might call them, because they really are passive and non-participating in almost every aspect of a class action, aligning those interests with the interest of their representative. Now, does that mean that actually happens in practice? Well, I think as our talk today has indicated, that is not reliably the case in many types of class actions. There are conflicts of interest. Now, the funny thing about litigation is the whole design of our adversarial litigation system in Anglo-American civil justice is the adversarial system. It's about a conflict of interest. The plaintiff and the defendant want different things. Their interests are in conflict. And it is that conflict that brings to the fore the legal arguments and factual evidence that allows the court to make an informed and hopefully accurate and just decision. The irony of class action settlement is there are conflicts of interest between every single stakeholder in the class settlement process, except between the plaintiff's attorneys and the defense attorneys and the defendant. Except that very core conflict that's supposed to make the process work, there are conflicts of interest. But there, where the conflict of interest is a good thing rather than a bad thing, it's missing. And that's the crux of the issue that we heard about. Okay, now that's the background that I think it just simply seems to underline, to underscore what's already been said. Let me offer a few thoughts, either to take these ideas farther or maybe to add a different angle. What's the normative frame with which we should approach questions about how the Cypre Award should or shouldn't be granted or considered or used? We can look at it from a doctrinal perspective, and I think as a matter of doctrine, I really have nothing to add to what we've already heard. There's all these potential problems, both in terms of compliance with the rules, compliance with fiduciary obligations to absent class members, even potential constitutional issues that might render the use of Cypre Awards problematic or simply improper. As a matter of policy, do these same considerations point in the same direction? I think for fairly obvious reasons, the answer is usually yes. With respect to most of these, the answer is yes. But let me just raise a couple of questions here. So one is, if we are concerned, as folks around here often are, when thinking about what the role of the tort system is, what's the role of civil litigation? Compensation is one, but deterrence is another. Deterrence is another. And the funny thing about deterrence is you might make the argument that it doesn't matter if you're paying $35 million to class members who are actually injured and nothing to the lawyers. Or you're paying $35 million to the lawyers who are simply there trying to make money and nothing to the class. Either way, if a defendant has to pay $35 million, they'll think twice before doing whatever it is they did again. So, at least to the extent that we're concerned about deterrence rather than compensation, we might ask whether a Cypre Award is perhaps one way to approach achieving that goal. Now, it's not quite that simple, though, because it depends on how and to whom such an award is granted. The devil, as always, seems to be the case, is in the details. It's very different if the award is going to some entity whose interests are aligned against the defendant's interests, and therefore giving money to that entity really is unpleasant for the defendant. That if it's going to, as I talk about in my advanced civ pro class, Unilever gets sued for mislabeling ice cream, and the award basically goes to a charity, and the charity is the Unilever Foundation. That suggests that there isn't a lack of alignment between the defendant and the recipient of the Cypre award, such that any deterrence in a case like that would be merely illusory. One question that I have, and I have my speculations about it, but I'd be interested maybe in hearing more on, is why do these debates about Cypre seem to have a political or partisan valence? Everything that I heard from Ted is nonpartisan. Like I couldn't find anything thinking about it from a pro-plaintiff or a pro-defendant or a whatever this viewpoint or that viewpoint perspective. I couldn't find a lot to disagree with. And yet it does seem that there are patterns when you look at the judges who tend to be more sympathetic or less sympathetic to these types of settlements. It does seem to be a pattern in terms of which judges, in terms of their own ideologies or perhaps political backgrounds, that they might tend to be more or less sympathetic to this. And so I think that's interesting. I think that's a question worth asking. Why might there be pushback to something that seems nonpartisan and really is just about protecting the interest of consumers who don't have a voice in the class action process? I think that's interesting and maybe worth exploring. In terms of what to do to make the process better, what are the alternatives to Cypre awards? One of the things I'd love to hear some more thoughts on are there ways to structure, there might not be a lot of receptivity to this currently in the doctrine or among judges, but I think they're worth considering, and others have mentioned it. Aren't there other ways to empower rather than merely represent absent class members? And what I mean by that is, can we change the incentives that absent class members face so that it really makes sense, it's as a matter of just economic logic, for the class members to intervene and stand up for their own rights, rather than relying on the altruism of activists like Ted Frank. And so one of the thoughts there is, if you've got 1 million people in the class and $1 million to distribute, sending them each an email and saying, fill out this 6-page form and get it notarized so you can collect your $1 is not going to lead to class member participation in the class action. But what if instead the court just picks one lucky winner for the whole million? Do you think that party might have an incentive to stand up and participate and actually scrutinize what happened in the case? I think so, and I'd love to hear more about that from Ted. So I guess I keep talking about all these things I want to hear more from Ted about. So maybe I should stop talking, and we should actually hear more from all of you, and hopefully from Ted as well. But thank you for this opportunity to share just a few thoughts on today's talk.
Q&A now. We managed to get pizza. Big thanks to Sean and Will for going. And we'll have you guys grab it on the way out if that's okay with you all. But thank you so much.
So to answer one of those questions, why is there potentially a partisan divide on this? I think there are two aspects that have a partisan flavor to it. First of all, the Cypre money tends to go to left-wing organizations. Either that's because the lawyers bringing the lawsuits, choosing the nonprofits are picking left-wing aligned nonprofits, or that the generally legal aid societies and legal aid societies have sort of a left-wing tinge to them. But for whatever reason, you do have left-wing nonprofits coming into court and saying, please, please, please keep Cypre going. Cypre is great because it funds legal aid, because it funds these great nonprofits. And that is apparently persuasive to some judges on the left. The other element that has some partisan valence on it is if you create a rule that says the attorneys don't get paid unless the class gets paid, there are, when I say that class actions are a procedural joinder device, whether or not you call it joinder or something else, the key word there is procedural, but the left-wing view of class actions is as a substantive aspect, that the class action attorney is sort of acting as a private attorney general for the purposes of deterrence rather than for the purposes of compensation. That's not the system we have, but it's certainly a viewpoint that many judges and certainly many academics have. And the idea that attorneys don't get compensated unless their clients get compensated, which is the underlying argument about the problems of Cypre, doesn't appeal to some judges on the left. When right-wing judges rule against us, it's because they want to either defer to what district courts find, or because the corporate defendant has come in and said, no, this is a great settlement, we need this to settle our cases, and the judge goes along for that reason. But hopefully that answers your questions. I look forward to other questions, though.
All right, any questions?
What are we going until?
1:15.
Yes, sir. Well, I'll let you moderate it.
Oh, go ahead, Carl.
Thanks. Here. What would happen if you put Rule 11 sanctions on class action attorneys who don't get funds for their class? Would that be an effective deterrent rather than not having it be in the class case?
Sure, but we've never, ever gotten Rule 11 sanctions, even when the parties miscite law, miscite facts, miscite, the things that you're supposed to get Rule 11 sanctions for. Judges don't like giving Rule 11 sanctions, so I'd love to see Rule 11 sanctions being issued more often, but we for whatever reason, judges really hate Rule 11 sanctions. But we're still at a rule where attorneys are getting rewarded for Cypre, and we need to, walk before we can run.
Stephen?
I'm curious if you think that if Cypre was ended, if the result wouldn't just be that the attorney's fee request will just go up to fill in that gap, or do you think that it would actually change the overarching compensation to the victims?
Well, I mean, the problem is the larger problem of creating the illusion of relief. So until 2005, the classic way you created the illusion of relief is that you issued coupons. And you say, look, we gave out $40 million of coupons, and okay, yeah, they expire in a year. And okay, they're only good for flower delivery. And okay, they're only good for flower delivery, but you can't use them for the 2 weeks before Christmas, or the 2 weeks before Mother's Day, or the 2 weeks before Valentine's Day. But it's $40 million of coupons. And judges would value those as $40 million, and the attorneys would get $10 million, and the defendant would pay $1 million maybe when 2% of the coupons got redeemed. And that was how you created the illusion of relief. Congress passed 28 U.S.C. 1712 that said if you have a settlement with an award of coupons, you value the coupons at their redemption rate. And as if you were playing whack-a-mole, the parties still try to use coupons. They just say, these are vouchers, these aren't coupons. These are e-credits. No coupons here. And you have this plain statutory language, and judges don't like it and invent tests over whether a coupon is a coupon that appears nowhere in the statute. So, there's still some problem there. But the Cypre arose because it was harder to use coupons to create the illusion of relief, or because Google didn't want to give you, how does Google issue a coupon? So if you didn't have that illusion of relief, the parties would do something else to create the illusion of relief. The classic, I think we're still having problems with, is sort of the imaginary injunction, and we've won some cases involving imaginary injunctions, the Subway case, the Walgreens case, where there was injunctive relief, but the underlying injunction was pretty fictional. Or you do something else to create the illusion of relief. Will the attorneys demand more money? Well, the attorneys always want to maximize their money, but if they actually have to get relief to the class to do that, they're not going to get paid. If the rule is the attorneys don't get paid unless the class gets paid, they actually have to accomplish results before they can ask for the money. So if you would have a Cypre settlement where the $6 million of Cypre is completely imaginary and there's really only $2 million on the table, you know, either the attorneys can fight harder to try to make it a bigger settlement, but then that's good. We want them to be fighting harder to make a bigger settlement rather than just collecting $2 million off the bat. You know, it cuts both ways. What we have found is that if the underlying case has some merit and we come in and we bust up the settlement, they figure out a way to get actual relief to the class. And if the underlying case is a Subway or Pampers, where the underlying lawsuit was meritless, the plaintiff's lawyers sort of slink away and just accept zero. Yes, sir.
I was thinking of like a statutory fix. What if we could only get the Cypre award if it's from a jury? So you mentioned, you know, these cases, most class actions almost always settle beforehand. And I'm thinking of like the illusion settlement. The jury isn't going to be, I guess, sophisticated enough to say, oh, where did this attorney went to Stanford? I want to give the money to Stanford now. It's much more difficult. So I guess like it isn't so much like giving money to a third party being the problem, more so the way that it's being abused. Because you can see an instance where there's a class where the damages are only $1 per person. Instead of everyone getting $1, if there was some sort of mythical third party that could advocate and make this better, that would be better. But it's because the lawyers are so, I guess, unethical.
I mean, I'm not sure. Like, there's a settlement, and then the jury decides who the Cypre goes to, or
it has to go to trial. You can't settle.
Oh, you can't settle it. Well. I mean, that's the same as a rule that just bars Cypre. So, right, if you're actually getting to the trial and you're getting a jury verdict, there's no reason to ask for the Cypre. I mean, I guess if you prefer that the nonprofits get the money instead of the class members, but then you could have sort of collusive trials where everybody goes and says, we think the Cypre should get $6 million, and the defendant goes, yes, we think the Cypre should get $6 million too. I don't know what you do then. But if you're saying that you can't have a settlement with Cypre, well, I'm all for that.
All right, we go over here.
And so, in a situation in which the settlement is like completely non-distributable, like the In Re Google case, where it's like 4 cents per member of the class, what are you recommending in the absence of the Cypre? And then another way of asking that would be like, why couldn't you just have a rule where it's like only when you can truly prove that like the cost of sending the 4 cents like exceeds like the 4 cents, in which case it makes no sense.
So our view is that non-distributable, unless you're talking like $1,000, $10,000, is a fiction. Once you get into the multi-million-dollar range, it's not non-distributable anymore. And the reason is that if you put this out there and make class members make a claim for the money, you get a claims rate of under 2% and usually often under 0.5%. So everybody loved to say the Google settlement was only 4 cents a class member, but there are class action settlements all the time where it's 4 cents a class member. The claims process goes, less than 1% of the class members make a claim, and that 4 cents a class member turns into an $8 check. And that's exactly what happened on the remand in the Google case. It was $23 million. They made it distributable. You file a claim. You could even file the claim electronically. You got the notice electronically through Google on your Gmail account. and you got the notice, you filed the claim, and then Google will send you the money electronically. So, right, to the extent 20 years ago things, cost 50 cents to send out a check, we don't live in that world anymore. We have electronic money, we have Apple Pay, we have Google Pay, we have PayPal, where you can send these micro payments, but the payments aren't actually micro payments once you have the claims rate out there. So, there will be residual cases where you're talking a few $100s, a few $1,000s, send it to the US Treasury, then it's not even worth litigating over who's going to get the cypre. But when you're talking the millions of dollars that are actually getting distributed, they aren't actually non-distributable. In every single case where we've been told the money is non-distributable and we made them distribute the money, they've distributed the money.
Thanks. So I'm going to ask one, and then we'll head out so we can get pizza. But I have a question. Shocker. What are the benefits to these $1, okay, like a million people in the class, and we think that there's like $1 million. Like, is this just lawyer shenanigans that are happening, or is there like some good benefit that we think that should there be like a amount of controversy requirement for Rule 23 class actions?
I mean, the whole idea of a class action is that you're talking really small amounts, and whether you call that small amount $1 or $10 or $30, it's too small to bring the underlying litigable claim. And the Superman 3 salami slicing scandal where you're taking half a cent from every single person, you can steal a lot of money that way, and you need the compensation, you need the deterrence, and maybe, if it's too small, it won't be worthwhile for the attorneys to bring in. You rely on an attorney general to vindicate the $1 million, $500,000, $2 million, or whatever it is. But all class actions, you're talking generally, with very rare occasions like a Volkswagen diesel case where you're talking thousands of dollars, in a consumer class action, you're talking just small sums.
All right, well, thank you both. This was a great event. So.